Hi, good afternoon, everyone. Thank you for being here. My name is Magdalena Machalska. I'm one of the member councils in the immigration section of the Minnesota Bar Association and a former chair of the immigration section. I am happy and very glad to have with us today Reka Sharma Crawford. She's a co-founding partner of Sharma Crawford Attorneys at Law. Reka currently serves as the second vice president of the American Immigration Lawyers Association, and has been active with AILA for the past 25 years in many different capacities, including being a speaker, author, editor, and mentor. In 2021, Reka was recognized by being awarded the Edith Lowenstein Memorial Award for excellence in advancing the practice of immigration law. Also in 2021, the Johnson County Bar Association honored Reka with Advocate Attorney Award. This award recognizes significant contributions to the public interest by an advocate. In 2018, the Kansas Bar Association honored Reka with the Courageous Attorney Award, an award presented to attorneys who have displayed exceptional courage in the face of adversity, thus bringing credit to the legal profession. Along with authoring and publishing many legal articles, she's also the author of 3 children's books. Reka, thank you for being here today. I'm very happy to have you. As far as I'm concerned, you are the expert in our topic here today. I just want to note that anybody who has a question, please go ahead and write your question. And I'm gonna try my best to read them out to Reka, and she will do her best to answer all of them as we go. And with that, I will turn it over to you, Reka.
Thank you, Magdalena, and thank you to the Bar Association for this opportunity. I am going to talk about habeas because right now it seems like every immigration attorney has now become a habeas attorney. If you do any kind of removal defense work, if you do any kind of detention work, you know that right now the state of play is that getting habeas petitions on file to get either a bond hearing or release or any kind of due process whatsoever has become more and more important. So I do want to make sure I have put together a PowerPoint, but I will put out in full disclaimer that I am not a PowerPoint girl, which means I tend to go off the PowerPoint, or sometimes I'll be like, look, we're three slides down. Feel free to ask a question. I believe that if you've come and you want to have a specific question answered, please don't leave without having that question answered. If I don't know the answer, I promise you I will get you the answer. But in terms of habeas work, what we're seeing right now, right, in terms of what the board is doing, is that matter of hurtado is still out there. And for those of you who don't know what matter of hurtado is, it is the no bond case out of the BIA that basically says that the immigration court does not have jurisdiction to grant bond for someone who is an entrant without inspection, no matter how long ago that they came into the country. We all know that that is absolute garbage, but here we are. So what that's doing, though, is that it's forcing people to go into federal district court and ask a federal district court to make a determination that the interpretation of law, that the way that they are interpreting arriving alien is incorrect, and that the individual is still eligible to receive a bond hearing. That's one kind of habeas that we're seeing. Other kinds of habeases that we're seeing right now are people who are going in on just a routine check, an order of supervision. They go in for a check, they get taken into custody. People who are on parole, they are getting taken into custody. They've done nothing wrong. Their parole is still valid. Everything is great, still getting taken into custody. If you're watching the litigation out of the Northern District of Illinois, where they are challenging under Casanon Nava this entire concept of warrantless arrest. So what's happening there is that people are being stopped by immigration or even local law enforcement for that matter. They say, hold on, we're going to get immigration. They don't have a warrant for an arrest. They don't even have really any probable cause for the arrest, but they're taking people into custody. All of those flavors, if you see that kind of a fact scenario come into your office and you are talking about a person's detention. Next slide, please. Next slide. There we go. So if you're talking about the individual's challenge to an unlawful detention, what you're looking at that point is a habeas petition because it is a fundamental safeguard against that unlawful detention. If you're looking to challenge, well, my I-130 didn't get approved, that's not a habeas. Or I have a case where the person got picked up on an order of a reinstatement and they were immediately subject to removal. That's not a habeas. There are things that other collateral things that are occurring that do not necessarily relate to a detention issue. However, if those collateral issues has now led to an unlawful detention, then you can still use habeas. So what do I mean by that? So the types of cases we're talking about is, for example, someone has a bona fide determination on a U visa, but they're getting taken into detention. And the government saying, well, we don't think that that's a deferred action. That's a legal question, but keep in mind that you can challenge that through habeas because at the core of that is how is the person being detained? And is the person being detained lawfully, right? So
Becca,
go ahead.
there is a question. May I interrupt you? Okay, so we have a question. Are you seeing any rhyme or reason to those specifically detained at periodic check-ins and those not detained?
Yeah, so I mean, here's the deal, folks. Let's be real. What does the administration plan on doing? It is a numbers game, right? And so what you're seeing is there any rhyme or reason? No, there's no rhyme or reason because it's not about whether they have lawfully detained people or not. What is it about? If you look at it, what it's about is the fact that they want to show that we have 50,000 people in custody. All right. Now, the reality of it is all 50,000 people aren't going to be able to have access to an attorney or even habeas. So think about it from the mindset of an administration bent on doing evil. What do? You say, well, even if half of those people get a bond hearing or half of those people get out of custody, who cares? Because we're still 50% ahead. And you have to approach this administration with that thought. So if the question is my client going to get detained? Start with yes. Start with that assumption that yes, the person's going to be detained. What do you do with that then? You then have to have a strategic plan in place that says, if they take them into custody, what are they going to do? And then how do I show that that detention is unlawful so that I can gin up my habeas petition and have it ready to go, right? The statutory basis is that it is found under 28 U.S. Code 2241. That is your statutory basis for habeas petitions. It is not under other things. You can add in the Administrative Procedures Act. You can add in mandamus. You can do anything. But keep in mind that if at the core of your habeas petition, you are not addressing 28 U.S. Code 2241, then you're in the wrong type of filing for challenging whatever it is that you want to do. So keep that squarely in mind. So pull up that statute, look at it, and it's called a great writ for a purpose. It allows for certain things, and we'll talk about that in a second. But you want to go back to that statute and make sure that you are addressing it from that critical piece of that point of view. The suspension clause is also an important piece. You're not necessarily, and I mean, at least in my experience, I've had it raised at least by by one jurisdiction, by one judge. She raised it on her own and said, if I don't grant you relief, have I then somehow triggered the suspension clause? And what she was really saying is that if, the suspension clause says that the privilege of writ of habeas corpus shall not be suspended unless and until there are cases of rebellion, invasion, or a public safety risk. So again, the ability to challenge that unlawful detention shall not be suspended under the United States Constitution. And generally, what the court was asking me in that instance was, is there any other remedy available? Meaning that if I don't grant relief and address the unlawful detention through this habeas petition, because the government was saying I don't have jurisdiction, then have we triggered a suspension clause violation? That is not something that is being raised across the board. It is not something that I'm seeing or even hearing that jurisdictions are kind of, leaning into at this point. It did happen in one of my cases. It is out there. You should be aware of it. If that comes up, that's what they're asking you is there any other remedy? Like, can you go into the Court of Appeals? Can you do anything else if the federal district court does not review your habeas? That's the core question they're asking you about the suspension clause. What you want to do, though, is drive the issue back to the statute and say, no, this is really more about what the court can do. Next slide, please. And what is the statutory basis, or what is the statutory parameters of 28 U.S. Code 2241? First and foremost, it is that the district courts have jurisdiction to grant your habeas petition because there has been a proof or there has been a showing that there has been an unlawful detention. It applies to custody where, in our instances, it is the United States government who is holding them. So ICE is basically involved in the unlawful detention, or in like the Hurtado cases, it's the government through EOIR and the Department of Justice who are denying wrongfully these bond hearings, therefore leading someone to be detained without lawful authority. It also includes constitutional and statutory claims. So what that looks like is think about somebody who goes in for a check-in for just on an order of supervision, and then they are, they go in, they have been going in for years, all of a sudden they're taken into custody. They aren't told why, they're not told what's going on, they're not told any of those things. They're just said, we're going to hold you until we can deport you. Well, if you go back and look at the regulations and you look at the statute on orders of supervision, there's actually process, right? There's due process at play that says, here are the steps that ICE must take before they can revoke an order of supervision. Similarly, in the parole context, here are the steps that ICE must take before they can revoke parole. In the BFD deferred action situation, here are the steps that ICE must take before they revoke that deferred action. You don't just get to take it away. And that is where those types of constitutional due process claims are being raised, is to say, look, they violated their own regulations that allow for the protection of someone's due process rights before they're arbitrarily taken into custody with no recourse. And so that's what you're asking the federal court to look at and review and make a determination that, yes, in fact, it is unconstitutional. They may have had a right to take the person into custody. So put another way, let's say somebody was on a order of supervision. And the government now has reason to say, well, look, we can now effectuate removal. There may have been a basis for them to revoke that order of supervision. They just can't do it without due process. They can't do it without proper notice and an opportunity to be heard. And that's kind of what you're seeing in context with what's happening right now is these people being detained with nothing. They basically did nothing. And, all of a sudden they're finding themselves detained. And you ask the client, did they tell you anything? No. Did they give you an interview? No. Did they give you any notice of revocation? No. That is going to tell you that's a constitutional due process claim. Those are the questions that you need to ask so that you can make sure that you are formatting and framing your habeas correctly.
And
The,
Reka,
yeah,
if I can jump in, I actually have a question. What about, can you comment on, when you have a client arrested, the OSUP is revoked, and after the arrest, they're giving him the paperwork that appears, clearly should have been given before the actual arrest. Can you comment? Have you come across these kind of cases?
absolutely. And you're seeing it really in context with, like I said, with Castanet Nava, which even the court there in the seventh, in the Northern District of Illinois and the Seventh Circuit, quite honestly, found that, look, you can't unring the bell. You didn't follow procedure and you later come back and you say, oh, but here's a warrant. Okay, well, it's still a warrantless arrest, right? Because it's about the time, that moment in time when the person goes into custody. It's not about what we did after the fact. And similarly, on an order of supervision, they can go in and say, well, look, we gave them due process after the fact. Okay, but you didn't release them and give them due process. They're still sitting in jail. So if there was any reason or anything that they could have provided, they weren't given. The regulations are clear. The regulations don't say, and if you screw this all up, you can fix it later after the person is in custody. There's no such thing in the regulations. And that's what you have to keep pushing the court back to, is to say, look, we didn't write the rules. If we would have written the rules, we would have done a whole better job doing it, but we didn't write the rules. And they wrote the rules. The agency wrote them. They had this process in mind. It is constitutionally sound. They didn't do it. And so now that they want to go back and try and fix it later, I mean, they don't get to do it that way. Keep in mind, though, that the risk in what you have kind of described, Magdalena, is that what do they do if they say, okay, fine, judge orders immediate release, they're walking out to the parking lot along with their notice of revocation, and they hand it to the individual and say, well, we are now revoking your order of supervision again. Can that happen? Yes. Yes, that can happen. It is a risk. Is it happening? Not widespread, in my opinion. I am not seeing that widespread, but could it happen? The answer to that is yes. And the reason you have to be aware of that is because you need to make sure that you are prepping your client for some of these oddities that in a normal world wouldn't necessarily happen, but we're not functioning in a normal world. And so you want to be able to say, if the client says, well, if one time out, I'm out and I'm safe, right? No, not necessarily. Now, you can ask as part of your remedy that the court order that they not be redetained without proper due process. That's a valid thing to ask in your habeas petition, and you should be doing that so that you have that in the language. In addition, you can also ask the judge to make sure that they do not redetain as a retaliation move, meaning that in certain aspects, and again, I'm not seeing this widespread, so please don't take this as, oh my God, this is all kinds of crazy happening in the world. There is all kinds of crazy happening in the world. This piece of it they have not started doing, which they are redetaining people, because I think the federal district courts in particular, in my opinion, are doing a pretty decent job. Not all jurisdictions, most jurisdictions, though. I mean, there are, of the habeas, I think there's a website called the Habeas Docket, and they have now said that there's like 6,000 habeas petitions that have been filed across the country in immigration cases. That's a large number. A lot of those we are winning, and so I think the federal district courts are kind of savvy right now to some of the shenanigans of ICE. Keep in mind, next slide, please. One of the first things that you're going to face in a habeas petition is that you are going to run into a jurisdictional argument, meaning that the government's first knee-jerk reaction on habeas has always been, well, look, Judge, you don't really have jurisdiction because under the Real ID Act of 2005, it eliminated habeas review of a final removal order and channeled all of those reviews to the Court of Appeals via petitions for review. Yes, we all know that. That's true. However, remember, just because there's a final order of removal that has proper jurisdiction in the Court of Appeals, that does not mean, next slide, please, that does not mean that the Real ID Act is going to keep you from challenging the length or conditions of detention. That is not something that the Real ID eliminated, but I can guarantee you that is the number one thing that the government is going to try and raise before the federal district courts. As I said, I think that there has been some real traction in educating the federal district courts across the country to say, hey, doesn't mean that for challenging lengthening conditions of detention that we are somehow having to bring that in front of the Court of Appeals. It also doesn't make sense from a practical sense. And the courts are starting to understand that. And we've made some real progress. I think a few years ago when habeas work was all but dead for the most part because we were filing them not under Zavetas, and I'll talk about that in a minute, but where people were filing habeas petitions and the U.S. attorney's offices were going in and saying, wait, this really belongs before the Court of Appeals because they're really challenging the removal order. We were losing traction there. I think we have moved very far from that position now to where most of the federal district courts are saying, yeah, even with the final removal order, if they're challenging the conditions of detention, or they're challenging how long they've been detained, or they're challenging the process by which they became redetained, all of those things are not eliminated by the Real ID Act, and therefore they still are valid considerations under habeas. Again, what you're going to want to do in that situation is to drive your argument towards the clear line that says, look, Judge, we know there's a removal order. Everybody gets that. That part may, in fact, be before the Court of Appeals, but the Court of Appeals is not a fact-finding court. They don't get to say, for example, if immigration said, we didn't get an interview, and you now have a declaration from your client that says, I wasn't given an interview, that's a factual finding determination. The Court of Appeals is not a trial court. They are an appellate court, which means they review things based on a record. So how do you have a record on a factual determination and challenging detention before the Court of Appeals? You don't. It doesn't make sense procedurally. And so again, if you bring that argument back to the federal district court to say, look, these are about the facts of how this person became detention. This is about the facts of how long they've been detained. This is about the facts of the conditions of detention. Now you're in habeas land. You are not under the Court of Appeals jurisdiction. It makes no sense. The government will try and steer the car that direction, bring it back off that cliff. It's the wrong place for them to be driving it. And you want to be able to bring those cases. The case law is good on this. And I'm in Kansas City, so I'm in the Eighth Circuit. I always like to say, if the Eighth Circuit, well, you guys are also in the Eighth Circuit. So if the Eighth Circuit does something and we have favorable case law, we should celebrate that, because most of the time the Eighth Circuit is not a very favorable jurisdiction. But I will tell you that in this issue, even the Eighth Circuit has favorable case law to say, yeah, if it's an independent challenge to something that is not about the underlying removal order, that's a separate thing. Now, keep in mind, though, there are times, like I have a case right now that is I call it my three-headed Medusa case, because it has a piece of habeas challenge in the district court. It has a mandamus claim in another federal district court, and then it has a petition for cert or petition for review over at the Court of Appeals in the Eighth Circuit. So you may have those kinds of variations on complex cases. If you have that and you don't have habeas experience, or you don't have a lot of experience doing federal litigation, don't do those cases alone. Get a mentor, get some help, get some resources, because those kinds of complex cases take a lot of maneuvering and keeping those lines straight. So if you don't have that, it's okay, but you're going to want to get some help before you kind of take on one of those complicated Medusa cases. And again, feel free to ask questions. Like I say, I don't mind answering questions. And I always say that if you go to a CLE and you walk away without having a question answered, what was the point? So please feel free. And I just saw one question come up here. So it says, I'm an attorney, not an immigration one. Can I do brief service for people just to get them out of detention? I'm also interested in helping observers, protesters, and so on get out of detention, all as a volunteer. Right now, and I'm not sure what kind of practice you have, but like right now, if you have federal court experience, yes, help out an immigration practitioner who may not, number one, have the ability to understand PACER in the world of PACER, or who may not have the ability to, you know, write up some of these habeas types of, the bases for habeas. Criminal defense attorneys right now file habeas petitions all the time. And so even if you are helping or mentoring a immigration practitioner to say, look, you need to put in the requirements that says, hey, judge, issue an order to show cause. You don't necessarily have to have a separate motion for an order to show cause. Does your federal district court require summons? Do they require service? Do they require, are those practical pieces? Those are things that if you are an attorney that is not an immigration practitioner, but is a federal litigator, absolutely you should pair up with somebody who's an immigration attorney trying to deal with these detention issues. Because what will happen is you'll take that pairing to where that other individual who may not have immigration experience will rely on the immigration attorney for the immigration expertise, while you can rely on the non-immigration attorney to get you through some of the procedural aspects of it. All right, next slide, please. These are the three cases that, all habeas petition keep looking at. I mean, go back and look at these three cases because you are going to run into them over and over and over again. So the key issue, and just because they only talk about, like, for example, in Zyvedas, and I'll talk about the specifics of Zyvedas, but in terms of these cases, there's great language. So even if you have a mandatory detention case, you may want to read Zyvedas because it has some great language about how detention should not be the norm, that detention should be the exception and not the norm. And so go back to these three cases, read them. You can use them cross types of habeas, but again, it's partially because the language is so good. They're all going to talk about the Supreme Court case in INS versus St. Cyr. That's a back 2001 case that talks about the suspension clause. But again, great language to educate your district courts. But Zyvedas v. Davis limits post-removal detention. So typically what you're talking about there is somebody who has a final order of removal, was let out on an order of supervision because they could not effectuate removal. And now they're going in and being pulled back into custody and detention. Under Zyvedas, if you look at the post-order removal period, there's a 90-day statutory removal period. Zyvedas expands it to 180 days and says that if the government is trying to effectuate removal, then it's reasonably, and it's presumed reasonable, that they can detain the individual for 180 days. I will tell you that, let's say you had somebody that had a final order of removal. They went into custody at the time of that removal order becoming final. So that was 10 years ago. They go into custody. They sat in custody for 180 days. Government says we can't effectuate your removal, and they release them on an order of supervision. There is an open question as to whether or not the clock resets upon redetention. Be ready for that argument. There is some conflicting case law that it does not have a clear answer yet. So I imagine in all of these habeases, we're eventually going to have to come to terms with what does that mean? Does that statutory removal period restart? I think that the statutory removal period is clear on its face. I will tell you that there are courts who are disagreeing with that analysis and saying, nope, government gets to restart the 180 days, even though we know that they're not necessarily going to be able to remove them. And you're seeing that in the third country removal cases where individuals are getting redetained and they're saying, we're working on this third country over here, even though this person has no right or rhyme or reason to this other third country. We're working on it. Therefore, judge, give us our 180 days. There are jurisdictions that are buying off on that for sure. Demore v.
Okay,
Kim.
Reka,
Yep.
there is a question. I'm gonna read it. Petitions must be filed in the district court in which the client is currently detained. Is that correct? Many of our clients are being sent to Texas.
Yep. Hold that question. I'm going to get to it in the next couple of minutes, but I want to go through these cases real fast, but I will answer that question.
I have another one, Reka. There's another one. Can habeas petition be filed immediately when a client is taken into detention, or do administrative remedies need to be exhausted for some issues such as a bond request?
I will answer that one first, which is that, yes, file your habeas. Especially in the Hurtado context, what we know is that the judges are saying, we don't care about her, we don't care about anything. We're going to follow Hurtado until the board tells us no. And in the Hurtado context, of course, there's the Maldonado Bautista class action that is in California, in the Northern District of California. Keep in mind right now, the absurdity of what the immigration judges are doing is that they are saying, well, yes, we know there's a class certification. Yes, we know that the court there granted summary judgment for all people in that situation, but we don't think that's a final judgment. And therefore, we are going to wait until the court enters a final judgment before we follow it. It is gamesmanship, but that's kind of what we've come to expect. Because if you think about it, a habeas petition that orders the district court to have a bond hearing, well, I mean, it's literally saying you are misapplying the law. So for them to now say, we have some fictitious reason to not follow the Maldonado Bautista ruling, that is where they are. January 16th is the status conference on Maldonado Bautista. It may provide some remedy. For those of you who are dealing with these issues, I mean, at least here in the Kansas City court, I just filed a mandamus action to try and bind the Kansas City court to the rulings of the Western District of Missouri, in which the Kansas City court is located, to say, look, the jurisdiction has now already made a determination that all of this detention is unlawful, and therefore, Judge, we want a mandamus order that forces the immigration court to adhere to the rulings and legal findings of the federal district. Will it work? I don't know, but I figured there's enough crazy things that the administration does that we should try some of our own crazy things. So if it works, that's a good thing. If it doesn't, there's no harm, because we are already all going in and filing habeas petitions. But to me, the bigger issue is the unrepresented folks who are being denied bond hearings, knowing full well, right, that the interpretation of law is wrong. So keep that in mind, but do not wait. File it. They go into custody. There's no exhaustion requirement, and you can whether if it's under Zavetis where it's a post removal detention, there is no exhaustion requirement. Under Demore v. Kim, the mandatory detention challenges where they are claiming, or the government is claiming, that it is a mandatory, they are subject to mandatory detention. Again, no exhaustion requirement there, because after all, it's a legal determination as to whether or not the individual is subject to mandatory detention. That does not have a exhaustion requirement. And then, of course, Clark v. Martinez applies to Zavetis to inadmissible persons, which are basically your arriving alien cases. That one's a tougher climb, but again, great language in all three of those cases. So keep those. If you have not read them and you are starting to do habeas work, please go back and read at least those three cases. Next slide, please. All right. So the big issue is going to be custody requirement. So petitioners must be in custody at time of filing. So if you That does not require physical detention. It can be constructive detention. I will tell you that orders of supervision are considered considered custody. So are bracelets and what are those, the monitors that they get put on. Those are all considered custodies. That said, there is some conflicting case law, so you're going to want to really research it. There are some who say no, you must go into physical custody. Although, like I say, there are some distinctions that can be made in terms of um, whether the ankle bracelet and those kinds of things will satisfy. An order of supervision clearly does. And again, what you're driving that argument to is that is the person free to live their life without having ICE involved in their decisions about their liberty? If the answer to that question is no, I think you have an ability to go in and say they are in custody. In most of the cases that you are seeing right now, the person is going to be in custody because they're in jail and they are sitting in jail, and it's going to become very easy to make that determination. Now, next slide, please.
Rika, I'm gonna read a question. Any guidance or thoughts on seeking an injunction or other ways of preventing a habeas petitioner from being moved out of the jurisdiction that their attorney is admitted in before the petition is filed?
Yep, this goes to this exact slide here. Custody assesses at the time that petition is filed. Jurisdiction attaches at the time that the habeas is filed. So the number one thing you want to do is get that on file before the person is moved. And this is why I say is if you have somebody on an order of supervision or something like that, where you know there's a risk that the person will get taken into custody, you want to say to the client, look, the only way we can make sure that this is going to happen quickly is if we gin up this habeas petition before you go in for your check-in or you go in for any conversation with ICE. Does that mean, and I've heard some practitioners say that, well, I'm just going to, have ginned up habeas petitions for everybody. One, I don't think we have the resources. Two, I don't think we have the time. And three, I don't think you should have the client pay for something like that if you know that it's such a remote possibility. I don't think that's probably appropriate. Like if somebody is sitting with an I-130 that's pending, you know, could they be taken into custody? Yes, but we don't know when the interview is going to be. Like there's some moving pieces there. So I don't know that you knee jerk it and say, across the board, all of my clients, we're going to have habeas petitions ready. But those that are at risk, yeah, you want to make sure that you have that habeas petition ready to go so that you can make sure that if it needs to be filed, you can file it very, very quickly. Release after filing doesn't necessarily moot out the case. It just depends on what you are looking for. So if you are looking for, them to remove the bracelet off of your client or the tracking device off their phone, they're already outside of custody. They're not in physical detention anyways. So keep in mind that physical detention is not necessarily going to moot out the case. But in a lot of these cases where they're sitting in jail right now and they are released from custody, yeah, that is the end of the habeas petition. Unless the court orders, the federal district court orders that the bond hearing be conducted within 10 days, 7 days, whatever, and then they don't. If they don't, you can file a motion to enforce because at that point, the immigration judge is arguably in violation of the court order if they don't do it within that time. All right. I'm going to take some so some of the other issue that people were asking about is, is there a way to prevent someone from being moved from a jurisdiction? So one of the things that, in your remedy, you want to ask for is a stay of the individual's transfer pending the habeas petition. Now, again, this is one of those things that depending on which jurisdiction you are in, a stay of transfer is not necessarily the same where you're going to have the government come back and say, well, you can't tell us how to discretionarily move people. Yes, I can. They're a federal judge. And the stay requirements under the Great Writ says that they can take any any step necessary to preserve their jurisdiction. So you can ask for it, but don't panic if the person gets moved, because if you win the habeas, again, you can ask the court to require as part of the remedy that the individual be brought back to the jurisdiction. So that timing requirement becomes really, really, very important on how you do it. All right. Next slide, please. And I'm gonna run through because I only have like 4 slides left. I'm gonna run through them, and then I'm gonna go back and hit all of your questions, just so that I think some of these are gonna answer some of these questions, but then some of them also I saw that they were getting moved into another column after being read. I don't remember them, so I want to make sure that we go back and answer all those questions. All right, who is the proper respondent? Now, keep in mind that going back to the Rumsfeld case, the proper custodian of in your habeas petition, the named proper respondent is the person who is the warden of the jail. So if you're just naming Donald Trump, I know we all want to sue him, I get it, but that's not necessarily going to be the right respondent. You can add him in if you want to, but in reality, you want to name the custodian, the jailer of the warden of the jail that your detention facility you are in. In addition, you are going to want to name the Department of Homeland Security, because the jailer's going to come in and say, Judge, I do what they tell me. They're not a named respondent. You can't order me to do anything. That is an argument that the government was making early on. I think since then, people have corrected that. And so now the issue is make sure that you are naming. You don't have to necessarily name, Christine Nome. You don't have to name all those people. It's fun to do it. And if you want to do it, you can. But if time is of the essence, you name the custodian, you name the Department of Homeland Security, you name the Department of Justice if you have an EOIR situation, you can name the EOIR itself. But remember, you want to make sure you at least, first and foremost, have the warden. Otherwise, you're going to run into issues later. Next slide, please.
I'm gonna jump in with another question, Reka. Are any of your habeas petitions accompanied with CROs like CVIS revocation?
Yep, I'm going to answer. I'm going to get through the next 2 slides real fast, and then I'm going to go back and answer all the questions at once.
Okay.
Where do you file and what do you do? First and foremost, you're going to file in the U.S. District Court over the place that has the jurisdictional component over the place of the detention facility. So, for example, people in my jurisdiction are being held in Greene County. Greene County is in the Western District, but if they're in St. Genevieve County, they're still in the Western District. They're in the Eastern District of Missouri. They're not in the Western District. So you want to make sure that you go back and check if you have multiple jurisdictional, if you have multiple districts under your state, make sure you're in the right U.S. District Court, and then you're also in the right division of that court. So for example, in Kansas City, we have the Kansas City division, then we have the Southern division. Greene County is in the Southern division, but the immigration court is in the Kansas City division. So you want to just go in and do that research and pick the right place. Your filing fee is $5. It's generally the best $5 to spend. You can file a request to say, can we file in form of papyrus, but keep in mind that that's going to require a declaration from your client. It's going to require other steps that you have to take. Fork up the $5, tell your client, look, $5, do it, get 5 people to give you $1. If you have no money, it's faster. And if time is of the essence, you want to get that on file. The federal rules of civil procedure apply. So if you've never done habeas work or even federal litigation, this is when I go back to that question of other attorneys you can pair up with who do federal court litigation, and they can help you kind of navigate through what's going on in terms of the rules of civil procedure. There's also one thing called the habeas rules. Now, the Eighth Circuit does not adhere to the habeas rules, and most of the district courts in, at least here in Kansas City, do not. Check your federal district to see, does your federal district apply the habeas rules. It has certain requirements that are different than generally under 2241, but please go back and look at that and make sure if your habeas rules apply. If they don't, you're under the statute, the general statute under 2241, and you'll follow that along with the civil rules of procedure. Once you file, what will happen is, and next slide, please. What will happen is that there are certain things that you have to look at. Number one, if you are not admitted to that jurisdiction, you are going to need a sponsoring attorney. And then you will need to also file a motion for pro hoc vice. What pro hoc vice means is that it gives you special permission to practice before that particular court for that particular case. So if you're filing 10 different cases, you can't just clump them under one habeas or one pro hoc vice motion. You can, unless you're filing them all at the same time, then you probably could. But generally what will happen is that you will file your habeas petition, you will file your motion for pro hoc vice. A month later, you come back, you have another habeas petition. You have to do that over and over again. Most jurisdictions have a pro hoc vice fee that has to be paid. So you want to, again, make sure that you look to your jurisdiction and say, what is that fee? That fee is $100 in the Western District of Missouri, but I know that in other jurisdictions, it can be $150, it can be $200. It's nominal, but keep in mind that you are going to have to pay that. Temporary restraining order considerations. Do you file a motion for temporary restraining order or a TRO motion? That is a case-specific question. If the question is, if it's simply to, let's say that ICE will say, well, if you file a habeas, that's great, but we're moving them to Texas tomorrow. I have found in my jurisdiction, and I file enough of these, and I have a good enough relationship with my U.S. attorney that I will reach out to the U.S. attorney and say, hey, we just filed this habeas. Are you really going to make me file a TRO? Because if you do, I need to know, and then I will file the TRO. You want to have that conversation because if you do file a TRO and the judge says, well, did you talk to the U.S. attorney? And the U.S. attorney says, well, no, judge, they never talked to me because I had told them that we would stand down and I was going to tell my client not to move the individual. That is a bad place for you to be, right? Because your credibility is everything in front of the federal court. And so take that moment, and most of the time the judge will ask, have the parties conferred before you've created this crisis, because a TRO filing goes quickly. And what you're basically saying to the judge is, stop everything you're doing. My case is so important and has such an emergency, I need you to look at it now. If that answer isn't, yeah, there's a real reason to do that, don't do that. If there is a reason to do that, definitely do that, but then be sure you can outline what that emergency is that the court should be giving it its direct attention right away. Even if you say, well, I didn't file it with my habeas petition, but now things have changed and 4 days later something's come up, can I go back and file that TRO? Absolutely. There's nothing that says no. And you can put in your TRO motion, here's why I didn't file it originally, but here's what's changed now, judge, and we need you to act because this is what's going on. In the CVIS cases, we used the TRO across the board. We filed them because what was happening is people were afraid that ICE was going to go in and detain them because they had been all thrown out of status and they were being told that their visas had been revoked, and it was creating chaos. And more importantly, there were some universities that were not allowing people to go to school or attend classes. That's an emergency, judge. Look, we're 2 weeks away from finals. These kids need to be able to go back to school. You have to act because the government has created this crisis. So that's kind of the level of analysis that goes in. Not every habeas petition is going to require a TRO. A lot of mine, I'm not filing a TRO right now, and simply because the U.S. Attorney's Office has basically thrown in the towel on the Hurtado cases and is basically filing a case that says, we know we've made these arguments and we've lost in the jurisdiction, and therefore we're filing it because we have to respond, but really we understand we're going to lose. And the judges are not even sometimes waiting on a response, but they can. Once it's filed, once your application has been filed, your petition has been filed, the court, again, this is very jurisdictional specific in the Western District of Missouri, within our habeas filing itself, we ask the court to issue an order to show cause. That order to show cause says to the government, tell me why this habeas petition should not be granted. It is the burden shifts to the government to show why detention is lawful and why the habeas should not be granted. Most of the time, you're going to get jurisdictional arguments, like I said, and then you will then, one way or the other, the U.S. Attorney's Office is not always going to get notification that that order to show cause has been issued. Some jurisdictions will say, well, you still then have to get a summons and serve the U.S. Attorney's Office. Other jurisdictions, like in my jurisdiction, I literally, when I file the habeas petition, I send over a courtesy copy to the U.S. Attorney's Office and say, look, the order of supervision, the order to show cause is going to drop. You need to be aware of it. They start to watch. The minute the order to show cause drops, they enter their appearance, and then they will file their response in due time. Once they have filed their response, you file a reply. In the habeas nomenclature, that is called a traverse. And a traverse is just that. It's a reply to their response on why detention is lawful. You will usually, the court will give you time, a time deadline to say by when you have to file that traverse. You want to file that traverse. One thing that we are seeing, and we're starting to see bubble up across the nation, is this idea that the government is no longer filing a response. They are doing nothing. And so now they're sitting there, and why? Because they're losing the Hurtado argument so much across the board that they've just said, we're not going to worry about it. At that point, what do? You can file a motion for an order of the court to grant the habeas, or you can, and again, local rules are everything. Some judges will allow you to call the clerk of the court clerk for them, or the law clerk for them, and say, they didn't respond, what are you going to do? I had a case where the government didn't respond. The law clerk called the U.S. Attorney's Office and said, hey, are you going to respond? And they said, maybe, we think. They gave them a continuance. They didn't respond by the continuance date. And the clerk's office, or the law clerk, called the U.S. attorney and said, now you've missed 2 deadlines. What are you going to do? And at that point, the U.S. attorney said, well, I guess I have to file something. They filed something. We didn't even file a traverse, and the court granted the habeas, but they were just making sure that they had given the government an opportunity to respond. None of these cases, for the most part, are being appealed, which is also very, very interesting, because they know, especially in the Hurtado context, how bad their legal position is, that they're not even appealing them. But again, it's a numbers game. So they figure, so what if we lose, 500 cases, but we have 1,000 people who say, I give up and I want to leave, they still come out ahead. Okay. So that's how that process goes. Now, I am going to answer all of your questions. Next slide, please. And I'm going to go back in and answer some of these questions. Are you seeing any rhyme or I think I answered that one already. Petitions must be, I think I answered that one already. I think any guidance on thoughts on seeking an injunction or other ways of preventing habeas petitioners from being moved? I think I answered that question already. Is there any open question, Magdalena, that somehow I missed through all of these?
Yeah, I think the question, are any of your habeas petitions accompanied by with TRO, CV, like the CV revocations? I don't know if you already answered that in your PowerPoint
Yeah, I think
there.
I answered that question. If somebody is a follow-up to that question, I'm happy to answer it. But I think I did answer that question as well. Oh, there's one open question. Is this okay? Yeah, I think that's the only one that's not been answered. With these habeas, so again, if there are any other questions, I'm happy to, I think, in the last few minutes, answer whatever those are. But the thing that you have to keep in mind right now with these habeas petitions is that time is of the essence. You can't ever go into court and say it's an emergency if it's not an emergency, right? So that's why I say, when I come back to the TRO question of, especially right now, we're getting ready to look at the holidays and things like that. I'm getting ready to file a TRO today on my mandamus case because, the government is continuing to, I mean, the immigration judges here are continuing to say, we know that our interpretation under Hurtado has been shot down now more than 250 times, but we're going to continue to do it. And what they're basically saying is that each individual must have their own individual habeas order, which is great for represented people. It's not so great for those who are unrepresented. And so the emergency there becomes that there is a colossal failure of due process for a vast majority of people in detention, and therefore, the judge must intervene to correct course because of what's happening and the way that the immigration court in Kansas City is acting. They know that it's
Oh,
coming. I will tell you that they've been served with that lawsuit, and I think they are, and the U.S. Attorney's Office are all waiting to say, please, federal court, give them an order that kind of solves this, so that we're not having to deal with 60 million habeas cases all day long, which is currently what the U.S. Attorney's Office is dealing with. Know your
Reka,
jurisdiction. Yeah, go ahead.
I actually, I was going to ask you a question. Can you comment a little bit, maybe based on your experience, have you had any cases where the, your client was actually deported while you were litigating the habeas petition?
I haven't had that happen yet. I'm going to touch wood on that because, crazy world we live in. But I know that there are people who are having individuals removed while the habeas petition is pending. Again, the issue is that I don't know that moots out your habeas, because the government's going to say they've been deported, the habeas is mooted out. That's where the government's going to go. Check your jurisdiction, because this is going to be very jurisdictional specific. We unfortunately are in the Eighth Circuit and have some bad case law with regards to that, because I do think that the Eighth Circuit's going to say that it has been mooted out. But you're going to need to kind of go back in and see if there's any shred of argument left to say it isn't mooted out. If the habeas petition, let's say, was challenging unlawful redetention, and the court says, yes, it was an unlawful redetention, I think at that point, you can go back in and ask for an amended order that requires the government to bring the individual back. Will you get that? I don't know. We're in a tough jurisdiction in the Eighth Circuit, but certainly there is a mechanism there for you to go back to district court and say, we weren't on the habeas, but they have now frustrated your order as a matter of law by acting in violation of, especially if there was any kind of a preliminary injunction in place that said that they couldn't remove them. Certainly that's a cleaner case where you can say they violated the preliminary injunction, and therefore they should be ordered to be return the individual. But even if it isn't, I think it is one of the remedies and one of the powers that could have happened. And the issue becomes is that they violated your right as counsel to know that they were going to deport the individual, and thereby frustrating your ability to file that TRO in the first instance. So my position is their bad conduct and their unconstitutional conduct by doing something that is contrary to fairness. I mean, you had a right as represented counsel. The U.S. attorney had a duty to tell you that the individual was going to be removed, so that you could have filed a TRO, and that you would deny that should then somehow allow the court to enter a remedy that would not frustrate that order. I think that line of logic does have some weight. Go back and look at it. There's some good cases out of the Ninth Circuit and I think the Fourth Circuit, but we're in the Eighth Circuit, which is a tough battle. Distinguish it the best you can. But if the client wants to fight, that's how you fight that.
Another question, if I may, Reka. What's the time period? Can you comment a little bit how long, on average, these kind of petitions take you to kind of resolve and get the client released?
It depends. On the Hurtado cases, like I said, the U.S. attorney is basically all but thrown in the tower. And so those cases are moving very, very quickly in my jurisdiction within a matter of days. Even on the judges that some of the judges are requiring full briefing, it's probably about 30 days. Mentally, you should be prepared for about 30 days by the time you will get a decision. I've had one judge, though, that has been sitting on a habeas petition for months, which kind of defeats the purpose, right? Because the habeas is it's unlawful detention, and now the detention is continuing. But So those kinds of things happen. You can sometimes kind of, if there's a change in circumstance or something else is going on or the conditions have deteriorated, you can sometimes gently file a notice with the court to say, hey, this is what's changed, and it kind of will provoke them into action. But that traditionally, in my experience, is the exception, not the rule right now.
Thank you so much, Rika. We are at 1 o'clock. Do you have anything else to add?
No, I think that every one of us should be trying the best we can. I wish you all, lots of success in filing these. Don't be afraid of it. The key is going to be, please get yourself a mentor, because right now the one thing is that immigration attorneys in these filings, we have the upper hand. So if you don't know what you're doing, it's okay. Get the help you need right now. There's training all over the place. Don't do it alone. But also be mindful that if you're getting the help of somebody, that your crisis isn't becoming their crisis, because all of us are kind of strapped for time and strapped for all the chaos that's going on. But other than that, go fight, win, and happy holidays to you all.
Thank you, Rika. Happy holidays. Thank you for being here today. And everyone is going to receive a copy of the PowerPoint on your emails. Thank you so much and happy holidays.
Thank you, everyone.